I will retell about what I had learned during my semester in international class. First, we talk about international law and law of nation. Actually, international law is different with law of nation. International law has a wider scope than law of nation. International law is a body of law that regulates all the activities that happen in every entities, so that they use modern approach. Meanwhile, law of nation is only the signs of the right and the obligation which happen in the relationship between the state, so that it use traditional approach. And why the international law has a wider scope? Because international law consists two components. First is private international law, and second is public international law. Private international law is only regulates the person and the entities. I mean that the relationship between the person and the entities. And the public international law has the same meaning with the international law. It's regulate all the activities, so that there are also the primary source, which is international treaties, the custom, and the general principles. There are also two theories based on the international law. First is dualism theory, and second is monoism theory. First, if a state declares itself as the dualism state, it means that they use dualism theory. The dualism theory defines that a state may choose which one law is more suitable to apply in the court to solving the case, so that if they use national law and in other state that case is more suitable to use international law to solve, it means that their own national law already prevails the international law, so it may cause a conflict. Meanwhile, the monoism approach is for the country which use one single legal system, so that the international law and the national law already collaborated and incorporated, and they use it to apply in the court to solving the case. There are also three primary sources in international law. There are three. The first is international treaties, the second is custom and general principles of law. And then there is also subject of international law. The subject of international law consists of states, and then the international organization, which must have a member, and then the clear organization structure. And then the third is Holy Throne. Example is Vatican, which had signed by Lateran Treaty in 1928, so that the Vatican is a world peace place, that it means that can be removed as the subject of international law. And then the last is the belligerency. Belligerency is the big number of the people with the power and authority to spread themselves from its country to form a new state. Now we talk about recognition of international law. Recognition is a process of an act to admit and acknowledge another state by the existing state, which the state had complied some elements to form a state. The recognitions divided to two types. First is recognition of state, second is recognition of government. Recognition, once the recognition is given to a state, it cannot be withdrawn, but if it's only give to the government, it still maybe can withdrawn lawfully, because the recognition it's giving to a state, it means that it also giving to give the recognition to the government too, so that it cannot be withdrawn, because they already recognize both of them. And meanwhile, the recognition of state, it mean recognition of government, it's only recognize the government, doesn't mean that they recognize the state too, so that it still can be withdrawn by another state which admit before. So there are four types of recognition of states. The first is express recognition. It's via diplomatic letters, statement, treaty to express their recognition. Example is Japan. Japan recognized Korea via Peace Treaty, Article 12 in 1951. And then second is implicit recognition. Implicit recognition, they send the diplomatic agent to another state to express that their recognition. The example is British Minister Foreign Affairs, that they established the relations, diplomatic relations with the government of Namibia on March. The third is collective recognition. Collective recognition is via international treaty or the multilateral conference. The example is ASEAN, OPEC, and then the fourth is premature recognitions. Premature recognition is the recognition is giving to the state that doesn't have the clear territorial. Example is the recognition to the Bosnia Herzegovina, Croatia. The state received the recognition, but doesn't have the clear territorial when during that time. Okay, now we talk about the recognition of government. There are also four types too. The first is de facto. De facto is not a legal recognition, it's only contemporarily, because it has not acquired sufficient stability. Example is the Iranian Revolution. And then the second is de jure. De jure recognition is a legal recognition. It means that after they got the jure recognitions, during period of time, they found that the state has fulfilled all the requirements, so that the state will grant the jure recognition. So that it means that the factor is the step towards to the jure recognitions. The example of the jure recognition is Indonesian recognitions during 1945 until 1949. Then the third is belligerency. The belligerency recognition example is UK recognized the Greek belligerents during the Greek Wars of Independence. And then the last is recognition of national liberal movements. The example is the 70th state recognized the PLO, but there are the PLO in that time haven't have the clear territorial. now we are talking about state responsibility. Every state has their own responsibilities to their own people, but if a state has bound to the international community, so that they will have the obligation or liability to associated to the international community status as the member of it. And if the state has made a breach, so that it will be divided into two types of the breach, intentional and negligence. If intentional, it means that they realize that they are part of international law, but they purposefully intend to make the breach. Otherwise, the negligent is when they realize that they are the part of international community and then they do the breach, but they lack of the responsible cares. I give you the simply example. Once you arguing with your neighbor, and then you're not agree what they are talking about, then you're very mad. You throw the glass of the water to his face, and then the sprites of the glass fly through his face, and it make his ruin, or I mean that how I call it, maybe ruins his face, so that it will cause a loss for him, and then that called intentional breach. It means that you directly make a damage or loss to him. You intend to do it. But if negligence is example is like you are going with the neighbor, and then you didn't throw the glass direct to him, but you throw the glass to the floor, and then the split of the glass fly through his face. It means that you are not intend to throw to him or to making him hurts, but you're just want to relieve what you're angry. That means that you're not intend to do, and that called negligence. So that every state will arises their responsibility if they are making a breach, and the breach will solving into two types. The first is intentional, and then the second is negligence. For me, human right is something that is a right given by the God, since we are found exist in our mother fetus, and it cannot be harassed, abused, or withheld by the other people, or by the other groups, or by the other state which more powerful than the individuals. So that the human rights actually must be protected by the organization, by the state, by the government, or by the international law, so that there is a regulation to protect people human rights. Then they are the foundation of the international human rights law. There is a Declaration of Human Rights which found in 1948, and then inspired the other convention, which are International Covenant of Civil and Political Rights, and International Covenant of Economic, Social, and Cultural Rights in 1976. So that every state which bound into international treaty will have the duties or obligations to protect or to respect, to fulfill the human rights. To protect is mean that the state is required to protect the human rights against human rights abuse, and to fulfill is mean that a state is requires to take positive actions to facilitate the enjoyment of basic of human rights, so that the obligations or the duty is must do by a state which related to they are the parties of the international treaties under the international law. Okay, the last is jurisdiction. Jurisdiction is a power or the authority of a state to affect person, the property, the circumstances in its territory. The jurisdiction may be through the legislative, executive, or judicial action. In international law, they will focus on the criminal law, and then the civil law will hand it or level over to the national control. And then actually there are five kinds of jurisdiction. The first is territorial jurisdiction, nationality jurisdiction, and passive personality jurisdiction, protective jurisdiction, and the last is universality jurisdiction. I will talk one by one. First is territorial principles. Territorial principle is based on the defendant act, or there is exclusively authority for a state to deal with the criminal case which issue in their territory. It has been modified. Official from one state to take an act within another state in certain circumstances. For example, in 1994, Israeli and Jordan was born in the peace treaty, and then this means that under which Israel criminal laws is applicable to the Israel nationals, and then it also to the specified areas of Jordan, so that it measure that the law, it measure that it can be taken by the Israeli to enforce such law. So a state may have are free and have they are free and have the right to decide the right to arrange of each one to exercise certain jurisdiction of each national territory. Okay, now we talk about nationality principle. Nationality principle recognize that sovereign can adopt criminal laws to govern of a conduct of the nation of the sovereign national, while the sovereign is outside of the borders. It means that these principles is a law that allowing the sovereign to absorb the law which make crimes of each national, and then to enhance the conduct is not illegal, whereas the place the criminal is performed. For the example, Mr. A is Indonesia citizen, and then he's selling drugs, and the act is start in the Singapore, and then it will be end in Malaysia, but the law which used to punish him is Indonesia law. It means that he cannot claim that in Singapore or in Malaysia that's not illegal. Maybe they are not. Yeah, maybe they are not they have no the regulation to regulate about the selling drugs. For the example, so he can claim that, oh yeah, he have no fault, he have no violates the regulation, but actually because he's a citizen of Indonesia, so and then Indonesia has actually regulates about the drugs, which we call narcotica, yeah, so that it will be, yeah, it will be punished by the Indonesia regulation, and not by the other laws, because of the nationality principle. And then the third is passive personality principle. It's recognized sovereign to absorb a criminal law that apply to conduct of a foreign national who commit crimes against the sovereign national, while the sovereign national are outside of the sovereign border. It means that the main point of this principle is mean that the law which will be used to solve is the law for the victim locations. It means that where's the location of the crimes, and then the law of the place will be used to punish the defendant, who commit the crimes. And then for the example, in 1888 there was a case, the cutting case, which as the leading of this principle of the case, the US citizen has made a defamatory publication which against the Mexican citizens, and then the Mr. Cutting is as one of the American citizen was arrested while in Mexico, and then the Mexican claims that the Mr. Cutting is it was convicted offense the Mexican law, so that it means that from this case we can know that the law which apply to a crime is the law based on the victim place, from the victim location. Third is protective principles. It's recognized a sovereign to adopt criminal laws which to exercise jurisdiction over individuals which commit criminal acts outside of its border, which occur outside of its border. The acts means that the acts something that they do which can be threatened another state security, their territorial integrity, their political independence. For the example, in the Mr. H-Man case, the Israeli court that has based on the jurisdiction on its jurisdiction on this principle, it say that the Mr. H-Man has against the law with which commit the criminal acts because he has affected to the against the Jewish people, their vital interest of the Israel, so that Israel court hears they use protective principles because the Mr. H-Man has did an act which threat a state, so that a state may be in danger because the vital interest is something that important for a state, so that it may be in danger. So they use this principle to solve the case. The principle. This principle is recognize a sovereign to adopt criminal law that apply to conduct performed by any person in anywhere of the world, that the conduct is recognized by a national as a world concern, as a universal concern. The example of the universality principles is piracy, ISIS, genocide, torture, crime against humanity, crimes against peace, and the war. Last but not least, I want to say thank you to Miss Yogebet Arundika, which had teaching us for a long time. I also enjoy during the time to learn international law really, and yeah, thank you.